I imagine you can hear me. Do you need this for the recording?
Yeah.
No. Okay, fine, good. Well, we are scheduled to have 4 speakers. We have 3, and the time to start has arrived, so I think we should go ahead and begin. I want to thank you all for joining us. This is one of the academic sessions, and our focus today is on health, risk, and data protection. And we have 3 very good presentations ready to go, and we will begin. I'll ask each one of the speakers to make their presentation about 10 minutes. Is that good for everybody? Okay. And then we'll have some time for question and answer. So that actually should fit quite well with our schedule. And I'm sorry I don't have biographical information about our speakers, but maybe when you begin you could just say a few words about your background and your institution and then get us underway. So let's see. I have privacy-aware fall detection system for hospitals and nursing facilities. Yes? No?
That's my talk.
That's your talk. Would you like to begin? Wonderful. Please introduce yourself and your affiliation.
I actually have a slide to introduce myself.
Oh, and I'm Marc Rotenberg with EPIC, Georgetown Law Center. So.
Okay, good afternoon everyone. Welcome to my talk. I am presenting the paper A Privacy-Aware Fall Detection System for Hospitals and Nursing Facilities, which is joint work with Erik, Krempel and Juergen Beyerer. And let me just say a few words to introduce myself. I am a research assistant at Fraunhofer IOSB and KIT, where I work in the area of information security and technical data protection. So I am a computer scientist. And the project in which I work is called the Competence Center for Applied IT Security Technology, also named Castel. It is one of 3 competence centers for cybersecurity that have been founded by the Federal Ministry of Education and Research in 2012. And I'm particularly saying this because Castel is the center of the 3 that is an interdisciplinary research institution. So we have lawyers and computer scientists working together on projects. And one of the sub-projects of Castel was the work that I'm presenting today. So this fall detection system for hospitals, it has been motivated by the observation that the Western societies in particularly are getting older and older. And there is already a shortage of qualified nursing personnel in our hospitals. The goal of our development was pretty much to provide hospital staff with an assistance system in order to relieve them from such unnecessary tasks as patrolling the corridors of the wards at night times. So what is the scenario of our system? I just have to mention that in the meantime we call the system, our prototype system, NurseI. It is meant to monitor low frequented areas in hospitals, particularly the corridors, and particularly at night times when there is only few personnel on the wards. The goal is to automatically detect falls of patients and notify the nursing personnel on the wards. So from a data protection or privacy perspective, the first question would be, why do we do this based on video analysis? Well, when we talked with the hospitals at the beginning of the project, they told us that a rather important requirement for them would be that they are able to assess potential emergencies from remote. So if we would use other technologies like, for instance, portable sensors or sensors that are integrated into the floor to detect falls, then we have the problem that the nurses cannot assess from remote whether there is an actual emergency or just a false alert of our system. Okay, so that's why we developed a system based on video analysis. Starting with the next slide, I'm telling you how we try to deal with the privacy impact of such a system. So the first decision that we made when developing the system is to separate its functionality into distinct operating modes. So each of these modes has a different functionality and a different level of privacy protection. Most of the time, most of the cameras will be operated in the so-called default mode. In this mode, we execute a fall detection algorithm on the incoming images, and no one has access to the video data in this mode, and once data has been processed, it's deleted immediately. Then once our system has detected a potential fall, the system enters a so-called assessment mode. In the assessment mode, nursing personnel is notified based on mobile devices that they are carrying around, for instance, small tablets. And if they accept an emergency notification, they get an anonymized video stream in order to assess the ongoing situation. Finally, if the responsible nurse confirms that there's actually an emergency going on, the system enters a so-called emergency handling mode, and in the emergency handling mode, we deactivate the anonymization from the assessment mode. Instead, we enable the front cameras of the mobile devices that are carried around by the nurse, and we establish a bidirectional communication channel between our system and the mobile device of the nurse. For this purpose, and also to increase transparency of our system, you have to imagine that we mount small displays on the corridors next to our cameras. These are meant to explain to the patients and to the staff of the hospital what our system currently does. So on the upper left, you can see the state of the display in the default mode, in which it just explains that video analysis tries to detect faults on the video data and that no one has access and data is deleted immediately. Once the system has entered the assessment mode, the patients or everyone else also could see that a potential fall has been detected and that emergency personnel has been notified already. And finally, what you can see here on the third image is the video stream of the nurse that will also be sent to the display on the floor in the emergency handling mode. Okay, in this slide, I want to talk about the anonymization of video data that we use in the assessment mode of the system. We did a user study in order to evaluate various privacy filters for video data with respect to identity leakage and also with respect to utility, where identity leakage means that the participants of the user study were able to actually identify the person occurring in the obfuscated video, and utility means that the participants were able to actually recognize the activity that was going on the obfuscated video. And we, for instance, evaluated these 4 filters here. So we have the pixelization filter on the upper left, a Sobel filter doing edge detection on the upper right. We also have Gaussian blurring, and finally a technique which just reduces occurring persons to silhouettes. And it turned out that when it comes to detecting or recognizing whether there's actually a person lying on the floor or a fall has happened, then it's sufficient to use this silhouette technique, which also is able to hide identities of people with a high probability. Last privacy protecting mechanism I want to talk about is how to protect the video data that we send to the mobile devices of the nursing staff. So particularly in the emergency handling mode, we send unmodified video data to a mobile device, and in the worst case, or pretty much in every case, this video data shows patients in emergency situations, so it's rather sensitive data that we don't want to see on YouTube. So what we do is we integrate usage control technology into the back end and the mobile device, and also information flow tracking technology. Usage control allows us to specify requirements such as the video data from the nurse eye system must not be duplicated on the mobile device. So we have to make sure that such a policy is deployed, usage control policy is deployed on the mobile device. And the second thing that we have to achieve is we have to detect the actual images from our backend on the mobile device. So as you can see the steps here, in the first step the notification is sent to the mobile device, and once a nurse accepts the emergency call, the device requests the video stream of the respective camera, and before we send that, we make sure that the policy is deployed on the mobile device to protect data that we are going to send in the next step. And once this policy deployment has been successful, we start sending the images. When these images are received on the mobile device, information flow tracking will detect that they belong to our policy. So now once the nurse does something like taking a screenshot or taking a screen capture, which has the semantic of duplicating this data, our policy will be enforced, which means that information flow tracking is asked whether the data in the foreground belongs to the video stream that is protected by our policy. And if this is the case, then we enforce the policy, which means that the screenshot or screen capture action is inhibited. Right, so this is already my last slide. What we've seen so far is we do automated fall detection based on video analysis, pretty much because of the requirement that remote assessment of potential emergencies is possible. As you have seen, we provide a high level of transparency with the system, basically with these displays that are mounted on the corridors and that explain the system's operation to the patients and to the personnel. We prevent misuse of the system for monitoring patients and employees based on access and usage control, and also based on the anonymization techniques that we can apply to the images. And we can also prevent leakage of video data based on usage control and information flow tracking. And finally, we also use the usage control enforcement capabilities to make sure that video data is actually deleted after it has been processed. That's it. Thanks for your attention.
Great. Thank you very much for your presentation. So yes, our next paper is Reducing Risk and Minimizing Harm, the crucial role of good governance in preventing the abuse of health and biomedical data.
It's a mouthful.
Did I get it right?
Yeah, you did.
Okay.
So good afternoon, everyone, and my name is Leslie Stevens, and I work at the University of Edinburgh's Law School, and I'm a research fellow on a project called the Administrative Data Research Centre Scotland, and that organization focuses on facilitating social sciences research by using or reusing administrative data records in Scotland and the UK. Today I'm going to talk about the key findings and implications of research I did with my colleagues on the subject of harm and the types of harm that arise from data breach incidents. There's really three things that I hope you would take away from my talk today in the brief time I have. And the first is that a much broader understanding of harm and impact is required when we're thinking about data breach incidents. The second thing is that poor governance practices was the number one cause that we identified in our evidence review as precipitating data breaches involving health data. The third and related fact is that good governance is obviously crucial to preventing and mitigating harm and impact when health data are compromised. To set the context for this research, it's important, I think, to take account of the global rise in the incidence of data breaches globally. And in the UK, the proportion of health sector data breaches represent almost half the reported data breaches that were in 2015, and they represent 3 times more the number of data breaches reported from other public sector organizations. Not only that, the cost of data breaches in the healthcare sector was considered to cost almost double that of a non-healthcare record lost. You see there that it costs on average to an organization $363 if they lose a healthcare record versus $154 for non-healthcare records. The other important piece of context is, of course, the regulation and what that is going to do to the data breach regime in Europe. And obviously important here is the fact that the costs for data breaches to organizations are going to skyrocket, and there's the possibility of 10 to 20 million euros in fines depending on the nature of the breach or infringement of the regulation. There's even the prospect now for criminal sanctions, but also compensation is explicitly for both material and immaterial damage. These contextual factors relate to the key message from our research here, and that is the crucial importance, again, of good governance when you're talking about mitigating these costs to the organization, but more importantly, the cost to the individual. So the research that I'm discussing today was commissioned by the Nuffield Council on Bioethics and the Wellcome Trust in the UK. And the project was for us to identify evidence of harm arising out of the misuse or abuse of health data. We were an interdisciplinary team. There was 2 of us from Edinburgh School of Law, myself and my colleague, Professor Graeme Laurie, and we were joined by 2 others from Swansea University with expertise in computer science and social psychology. The underlying premise to the report was that there is always a lot of discussion about risks and the risks involved when you're talking about processing health or biomedical data, but there is very little evidence or studies to substantiate the types of harms we're actually talking about with this use of data. In particular, the funders perceive there to be a real lack of evidence or understanding of causes of data breaches, the types of harms that we're trying to prevent with good governance, and a successful way that we can actually prevent them. My team and I developed a 3-strand approach to this evidence review. And the legal strand, which is what I worked on, focused on gathering evidence of data breaches from primarily UK and EU law, from administrative tribunal decisions in the UK, but also from the UK's Information Commissioner's Office and their enforcement activities. We considered these to be more objective findings of fact, and we contrasted this to the psychosocial strand, where evidence of data breaches were gathered from charities, citizens' voice organizations, and general media to hopefully represent a more subjective account of the data breach from the perspective of the individuals involved. The third and final strand was a little bit more experimental, and we sought to gather evidence, or a mixture of both objective and subjective evidence, from social media, and primarily we used Twitter for that. As my primary responsibility was about the law and how the law interacts with data breaches, that's the findings I'm going to focus on today. The overall starting point for our project was to understand the regulatory environment in which data breaches are regulated in the UK and EU. And this was crucial to us to understand how individuals can interact with the law should they fall victim to a data breach. Obviously, in the UK, the key law is the Data Protection Act 1998, which is based on the directive. And as the slide says in its title, our research and what I'm talking about today is what the law currently does under the directive. At the end of my talk, I'll offer some very initial assessments of how the regulation might change things for victims of data breaches. But I think it's important to go back to the status quo, and you can summarize that relatively quickly. And it's that there's very meager opportunities for compensation or redress to individuals that fall victim of data breaches. Sorry, that was too quick there. The law in the UK at least, it compensates or understands that there's a prospect for emotional distress as a result of data breaches, but very importantly, this right to compensation is curtailed by the fact that damages must still be tied to or is contingent upon a causal connection to financial damages. And individuals in general are limited to seeking compensation or redress because they have to go to court for compensation, and they have to go to court to get orders to stop and delete processing. The cost in terms of time and energy is obviously very prohibitive to individuals in bringing the legal case, not least the fact that the damage will have obviously be done by the time these cases are resolved. So data protection law as it currently stands, we felt reflects a real lack of capacity to deal with the full extent of harm that could be caused by data breaches, and the law recognizes only a very narrow version of what this harm entails. We moved on to the evidence gathering phase of our work, and we did this with this understanding that the evidence would be also narrowed by this understanding of harm through the eyes of the law. We gathered our evidence and we categorized it according to the type of data breach involved, the cause of the data breach, and the type of harm that might have happened as a result. In this slide, you'll see how we categorized types of data breaches. So we would look at an incident and say, does this involve theft? Does it involve unauthorized access, the non-secure disposal of paper records or of hard drives, the technical security failures, or also more malicious acts where hackers are involved. And crucially, we found that the more unintentional data breaches were far more prominent in our review than the more malicious acts that you often see publicized in the media. And that relates to what we think is the key finding in our review, and that relates to the causes of data breaches. The funders were very interested to understand what factors are incentivizing or motivating data breaches to occur, especially at a rising rate. And the overwhelming number one cause was something that we called maladministration. And it's kind of a lumped category that represents incidents that we felt were caused by poor governance practices. This would fall on the more unintentional end of the scale when you're looking at unintentional behaviors or intentional behaviors to misuse data. And we distinguish between incidences of maladministration and human error on the basis that human error would involve chance, a one-off mistake, whereas maladministration showed multiple levels of failings of information governance. As a very brief example, you might have lost a USB drive. The data was unencrypted, but also the data were allowed to be transferred to that type of device in the first place. And these are all indicative of several levels of failings of information governance. Finally, we looked at each incident and tried to discern what harm or impact might have been caused to the individual, but also to the organization and the different public interests at stake. I think crucially here, our findings show that it's a much broader spectrum of harm and impacts than it is all narrowly understood as under the law. And interestingly enough, it was the potential for harm to occur that was the number one finding, that this idea that once data are compromised, individuals have to lay in wait until some unknown date where their data could or could not be misused. Again, emotional distress showed up quite frequently in the evidence, but as I said, in the UK, emotional distress is only compensable insofar as you can connect it to financial damage. So in our eyes, that is really no type of compensation or redress at all. With the evidence gathered, we sought to develop an understanding of the key implications for governing health data. And I'll come back to our key finding, which is that maladministration was the number one cause of data breach incidents. And we call it when things go wrong, but it really represents what we consider to be the epitome of poor information governance practices. And the evidence of this showed multiple level failings where simple procedures could have been enacted to prevent or at least mitigate harm or damage from going further. We decided as a group that these incidents were entirely preventable because of the crucial role of good governance. And I'd like to stay on that issue just for one more slide. Maladministration often represented very unintentional, careless behavior, not intentional, not malicious behavior. It often involved insiders, employees, contractors, those with inside access, who do not have the incentive or intention to actually abuse the health data that they are charged with processing. Yet, despite how careless or unintentional their actions were, as you'll see from the slide, these are real incidents that have actually happened in the UK or Europe. These careless incidents led to very severe incidents of harm and impact to individuals. The lack of a process to dispose data properly led to HIV positive patients' data being sold on the black market. And these are the types of serious incidents that need to be communicated to staff so that they know that their even careless, unintentional behavior can actually lead to a great deal of harm. Our overriding conclusion for the report, again, is that good governance is absolutely crucial. And I think it's clear to us what good governance is not. And for us, good governance is not just about consent or anonymization. Far more than the identities of the people involved are at stake, and that is often what technical solutions like anonymization revolve around. But more than that, the broader spectrum of harms that we found indicate that you need to also account for the public interest and how that is affected, especially in healthcare, where continuing rises of data breach incidents erode the confidence in healthcare organizations and healthcare professionals and those responsible for collecting and processing health data. Again, I want to make the point that we did distinguish between incidents of human error and maladministration. We do recognize that there's always the element of chance, of honest mistake, and that you cannot entirely prevent this through good governance practice. However, it was our conclusion that good governance can more effectively trigger appropriate actions at the right time in order to at least mitigate harm, and we believe organizations who are charged with health data have that obligation. So the next steps for our research is really to understand and identify what cultural and practical changes are needed to combat this rising incidence of data breaches in the UK. There are policies, there's procedures around the use of health data, but these breaches continue to occur and are actually on the rise. It may be that organizations lack a proper understanding of the incentives or disincentives around handling health data more carefully, ethically, and safely. The incentives are not just about the protection of individuals, but also to secure and promote their further use of data for important public interest reasons such as research. But we feel the disincentives are just as important here and need to be communicated so that all staff from all levels understand the full spectrum of harm and impact that can arise from even their most unintentional behaviors. On a more practical level, we felt that the evidence showed us that a one-size-fits-all solution to governance puts data at risk. We need more context-based, role-based, and use-based training for all staff in order to prevent the types of harms that we identified. Now, my last slide is really just some initial assessments on what is going to happen when there's a data breach under the regulation. So there's just 3 brief points. The first is that it's very welcome to see a much broader conception of harm under Recital 67 of the regulation. And this coincides with what we found in our evidence review, that it's not just about financial damages or emotional distress. A lot more is at stake when data breaches happen. The second observation is that individuals' rights to compensation for data breaches are guaranteed in Article 77 for both material and immaterial harm, but we feel that the time, value, and costs associated with bringing legal cases to get that type of compensation, that has not obviously been addressed in this. Third and finally, at the start of my presentation, I mentioned the new fines and the new measures that are going to be sanctioning of any potential infringements of the regulation. And it's clear with the rising incidence of data breaches, there needs to be different and stronger approaches to enforcement. The directive was often criticized for its lack of teeth. So I think it's going to be very interesting to see what type and severity of infringements will actually trigger this new level of fines. that was a lot to take in. So if you want to look at the report in more detail, it's on our website at masoninstitute.org. But thank you for your time.
Very good, thank you. Okay. So our third and final paper is titled A Purpose-Based Taxonomy of Personal Data in the Internet of Things Era. The example of wellness data.
Again, that was a mouthful. So let me just find the presentation. There we go. Great. So thank you for being here. I'm going to present a paper that we wrote with Claire Levallois-Barth, that is in the back of the room here. Our idea was to propose a purpose-based taxonomy of personal data, and precisely to connect it with the idea that this will lead to good governance models, to take up the point of Leslie, to good governance models within organizations. I want to start out by picking up a debate that started on the Twitter feed of this conference. Facebook, Google, and Palantir, as you know, are sponsors of the conference, and some of privacy advocates attending the conference felt that this was a problem. My point here is not to be part of the debate, but to pick it up and say, yesterday in a session, someone asked, does Facebook implement privacy by design? And the Facebook representative at the panel said yes. Obviously, there was a misunderstanding because the person who asked the question did not feel that Facebook implemented privacy by design, and the person at Facebook thought that he was. What I want to say is that the idea of working with companies to find the appropriate level of regulation of privacy by design measures is something that we need to do more of, because if we want to build models that are used and that are appropriated by companies, then we need to work with them to find good models of governance. And then on the other hand, we also need to fight against aligned incentives, and there's a need to refuse to take in systems and structures as givens. And so I'm not sure which side of the debate I'm on, but since I'm not sure, our idea was to propose this purpose-based taxonomy to precisely give users a chance to say which side of the debate they are on, and to pick up the point that Marc made in the previous session. We need metrics to understand which side of the debate we are as users on. So that was a full introduction, but our goal is precisely to make it easier for companies to govern their own data in a way that is compatible with the data protection approach, and that will help set the norms that we are seeking to promote through effective data protection regulation. So the first point that I want to make, picking up on the point that good governance is more than mere anonymization. Anonymization is hard to implement for companies in the way it's been defined currently in the European framework. There's personally identifiable information, which in Europe has a slightly different definition than in the US. There's pseudo-anonymized data that is sensitive for a reason, that has to be treated to provide some other measures of anonymity. And then there is anonymous data, which is data by nature anonymous, or that has been treated to become anonymous. And those conditions for companies are incredibly difficult to incorporate in their own governance models of data. So what we looked for in a new taxonomy, first of all, is what I was saying, is for the users to express their preferences, to express their privacy and their personal data protection preferences, so that everyone can know that the users have given their consent and for what they have given their consent. The second thing is we wanted our model to be independent from use cases, so that 5 years from now, it's not completely irrelevant. And we also wanted it to be independent from techniques, because as we are all very aware, 2 years from now, we don't have any idea how we're going to process the data that we're collecting today. A point that was raised in many sessions here is about further processings, because it's a point that the General Data Protection Regulation tackles not very clearly. There is much economic values that lies in unanticipated use cases that necessitate those further processings. There's also the point that the consent in the Internet of Things is harder to receive. The example yesterday in a panel was you have a connected scale. How does the connected scale ask you to give your consent if it wants to process your data in a different way? it is a problem that we need to solve. And the third point is that the compatibility of purposes is a legal uncertainty for those further processings. So if I collect the data for one purpose, and then 2 years from now I want to process it for a different purpose, I have to check that those purposes are compatible. What does that mean from a company's perspective? Our goal here was to propose group of purposes that would be compatible. So what we do here is take the example of the health sector to try and give an example of our approach. It uses 3 different use cases. The first one is I use a mobile app, and this first use case is going to be user-centric. The user has the control over the data he collects himself or herself. The second is silo-centric, and this is something we want to push for. It's the idea that the data is collected and immediately transferred in a silo, and throughout the presentation I'm going to try to convince you that those silo-centric models are something that we should be more concerned about or more interested about to find the appropriate level of regulation. And then the third use case is I produce health data that is very sensitive, but that is very useful for public interest or research purposes. And so all those 3 use cases are use cases that I think we're going to see more of in the coming years, and that we need to find the appropriate level of regulation for. I'm now going to move through the 3 use cases in some more detail. The first we called quantified self data, which is the data we collect to reach a better knowledge of ourselves. This is the user-centric model. It is produced in the sensors, and it is heightened by the Internet of Things, the pervasiveness of the Internet of Things. We're all going to have sensors that are going to measure some portion of health or health-related data, recording biological parameters, physical activity, and this data is going to be recorded by equipment we own. So I am going to buy a connected scale. I am going to buy a Fitbit. I don't have a Fitbit, but some of you may do. And for this first use case, there are clear benefits and also risks. Benefits are the know thyself, the idea of the quantified self movement, that through better knowledge and through better measurements of myself, I'm able to routinize best practices. I'm able to there's a list of benefits there. There's also the idea that I can share my performances with other people, and that's another kind of benefit because it can spread good practices. Again, this is a benefit of this use case. But there's also risks. The consent that I already mentioned is how do we get the consent of the user in through a connected device? And there's a security issue, obviously, because has been raised countless times in many different places, and here again, the security of the Internet of Things should be a major concern of ours from now. The second use case is what we call predictive personalization. It was touched upon yesterday in a panel about personalized computing experiences, and this is data that is used by companies, by private actors, to build personalized offers that we are going to receive and accept or reject afterwards. Here, the data can be produced by us, but it can also be produced by the chatter between things and their manufacturers. So if I buy a connected thing, it can record semi-identifiable data about myself. We're not quite sure if it's identifiable or not. It can be the number of steps I do in a day. It can be many things. And this can go to the manufacturer and be used to target more precisely the commercial offers that it builds. And what we want to insist upon is the development of silo-centric business models, which is several companies joining their data together in a silo and then being able to share and use data recorded by other companies in the silo. We've seen this starting to develop, and as it continues to develop, it is important that the users have the opportunity to understand how those silos work and have more information about those silos so that they can make more informed choices. Again, this is data recorded by equipment. The benefits are obviously higher profits for firms. They're able to target their audience in a better way, but it's also lower prices for the consumers because and this is something that we need to take into account. The risks obviously are unfair competition. If this data that is in a silo is not available to competitors, then some private entities are going to be able to target better their offers. Discriminations between people. and loss of autonomy because I'm not able to take the decisions that I would like. The third and final use case, and this is probably the one you know best about, is the health data per se. This is data produced within a medical context. It's related to our physical or mental health. It is defined in regulations, and it is shared across health suppliers. The idea is to deliver better services within the health system and across researchers to innovate. In that sense, the benefits are obviously better treatment and prescription. The idea being that you could you can do research based on this data to find better treatments and better prescriptions for the people, but also better patient experience, which is increasingly a concern of, for example, the health system in France. Again, here the risk is obviously the risk of discrimination and the loss of autonomy because people don't have information about themselves which they could possibly use to make decisions on. So this was our model, and the last slide is this idea that with those three categories, we are able, and this is something that we're going to work on the next steps, to develop public policy proposals for each of those categories. In the quantified self, we don't want to over-regulate because people should be free to do whatever they want with their own data. In the second category, the predictive personalization, we think that there is a higher need for regulation. And then finally, the third category, the health data, there is clearly a need to have very precise and very strict security, but also availability measures of that data because it can unlock a lot of value for all the users of the health system and beyond. Thank you very much. And if you want more information on this research, you have the website of the Research Center, which is the chair on values and politics of personal data within the Institut Mines-Télécom in Paris. And this is a pluridisciplinary research center where philosophers, social scientists, engineers, but also economists work together to understand this world of personal data we live in. Thank you very much.
Yeah, thank you. I thought these were three excellent presentations. And we have a bit of time for question and answer. Before we open it up to question and answer, if it's okay from the U.S. perspective, I wanted to give a few reflections, because all of your papers actually touched upon cases and matters that we've been involved with either through EPIC or at the Georgetown Law Center. And just to briefly reflect, you talked in the first paper about the privacy challenges of the fall detection system, where on the one hand you're trying to assure some privacy protection. At the same time, you need the ability in some instances to reconstruct identity, to de-identify your subject. And we had a Freedom of Information Act case against the U.S. Transportation Security Agency when the airport body scanners were first deployed in U.S. airports. And you recall these were devices that had the ability to see air travelers through their clothing as if they were naked. But they said, of course, that there was a privacy technique to conceal that particular image from the person who is viewing the air traveler. And then you do a little bit of research into the technique, and you learn actually that it can be turned off. So the person who's viewing the privacy protected image turns down the privacy preference, and now suddenly here's the whole image. So I think it's a challenge, obviously, and your paper addresses this. When you're trying to adopt techniques for de-identification and anonymization, you oftentimes ask the question, well, who will have the ability, if you've identified a privacy interest, to make the determination that that privacy interest is no longer present? And I think it's a very interesting challenge. To the second point about good governance models, we haven't done quite so much work within the realm of hospital administration, although I think your insight that most data breaches, most significant data breaches, are in fact not malicious, of course, which is quite an important insight, because the way we oftentimes talk about data breaches in terms of, computer hackers breaking into systems and all of this, but oftentimes just sloppy, or as you say, maladministration, sloppy administrative practices that result in the leaks of tremendous amounts of unencrypted data. That's oftentimes someone leaves a laptop in a car for example, and someone steals a laptop, and suddenly in the US we had 26 million records of American veterans, soldiers, whose medical records had been stored by a federal agency, now available to someone who has just taken a laptop. So I thought that was a very important insight. And also to a bit of ethics work as to harm, we have a case this year before the US Supreme Court. The case is called Spokio versus Robbins. And in that case, the US Supreme Court will be asked to answer the question, when a violation of a privacy law occurs, is it necessary also to show actual harm? So the person goes into court and they say the company is required to minimize data, the company is required to grant me access, whatever the company is required to do. Is it necessary in that circumstance, as the corporation has said, well, yes, that may be true, but do you actually have a quantifiable harm that supports your right to bring this litigation? So it's a very interesting point I think your paper raises about the nature of harm in the health records environment. And then finally to your last paper, which I thought was very good as well. This was actually my exam question in 2014. And if you go, we have a new casebook now. We've put all our old exams up there. But if you go to the website privacylawandSociety.org, you'll see my class at Georgetown. And in 2014, I asked my students, imagine that you were asked to give legal advice for a company that was launching a new wellness data product like Fitbit. What rules would you consider for the collection and use of data? What policies would you put in place? Because I really do want my students to understand from the business side what the best practices would be to ensure that privacy issues are properly addressed, even as you're simultaneously trying to launch a new and innovative service. So I thought that was, a really good answer to something we've been thinking about for some time. So thank you all again for these excellent papers. I think we should open it up now and have a bit of discussion.
Okay.
Please.
I'm so glad I get to ask you guys this, because this is something, as a data scientist, I think about a lot, which is something in between the last two categories you talked about, the sort of like Fitbit. Let's just say Fitbit gets all their data together, fully anonymizes it, and then models outcomes in 5-10 years, okay? It might be totally anonymized, so we can put privacy to the side for a second. And now, say I'm a data scientist working at Walmart, and I want to avoid paying health insurance for sick workers in the future. I can use the Fitbit anonymized data to model outcomes in 10 years. And I can ask questions of people who are applying that look like they have nothing to do with medical information. It's not a privacy breach, because you're allowed to ask questions of people who are applying for your job. But I could also give them scores. So I can actually avoid getting people that will eventually get sick, and I can save money on insurance. So that is a use case which I think is probably happening in the real world. And I don't know how privacy deals with that. It's not a privacy breach as such. You can even ask questions that are proxies for the kinds of things you know from Fitbit. Instead of asking, do you use Fitbit? You don't have to ask direct questions, you can ask indirect questions. So anyway, I just wanted to think what you guys, as privacy experts, how do you deal with that use case?
Wow. I actually think we need a whole new paradigm, and I'm not the first to raise this, of how we regulate, because when you regulate on the basis of whether data is personal or not personal, that isn't a category that really applies today. Because when you say, when you mentioned the data would be fully anonymized, and I don't know if all of you are familiar with Paul Ohm's work that talks about the fallacy or the big lie that is anonymization. So in my mind, when I'm looking at issues for work, I never consider anonymization to be foolproof. So for me, there are still privacy issues that are residual, even if data are de-identified to the most robust way possible. So I think my answer is not really an answer, but that I don't think the current categories of anonymous data and personal data offer the type of protection you need when you are using, or there are cases where anonymous data are being used to discriminate. And they do not technically come within the law. So I think we need to rethink our categories and look at purpose-based, possibly, regulation.
I have a response, but maybe we'll go to our other panelists, so please go ahead.
As I understood the question, you were talking about correlations that are embedded in data that will be found a few years ago and will then be used for other purposes. Is that right?
Yeah.
Well, I think the key problem is that even if we would be able to control what data sources are fused together, we won't be able to come up with metrics about such unknowns that may be embedded in data. So if algorithms can find some correlations in data with lots of efforts, the problem is, I guess, that we can't know that before, and I don't know if it makes sense to avoid designing such algorithms. I don't even think that it's possible. Yeah, don't have a good answer, I guess.
Yeah, I don't think that not saying those algorithms we're not going to design is a sustainable answer either. But I think that what you're saying in the other part of the correlation is that it enables companies like Walmart to have types of people. So making types out of, building the group of people based on the data that they have from Fitbit in your example. I think this is where the privacy implications are, when they build the category of people and they put you in this box. And when I was talking about loss of autonomy, I think that when you are put in a box with you not knowing what this box is about or how it was built, this is where the loss of autonomy happens, and this is where the privacy implications start. So in terms of the category that we offer, this is typically a silo-centric model because it's company shared from one company to the other. And I don't think that it's reliable to say, oh, this is never going to happen, because it will happen. I think that a much maybe more sustainable measure would be, okay, so if Walmart is using data from Fitbit to categorize employees, then let us know that you're doing it. Let us know that you will have access to the data that Fitbit is collecting or has collected before, and let us know that you are using this data to build categories to put us in those boxes that you're building. I think that's maybe a more sustainable approach too. It might not be sufficient.
If I could make just a quick comment, because Paul Ohm's name was mentioned. Of course, there's quite a lot of controversy about whether or not anonymization can succeed. Paul, I think, has given up. But on the other side, of course, is the work of people like Latanya Sweeney or even David Chaum, for that matter. We believe that anonymization continues to be an important goal, de-identification. We don't give up on the category of personally identifiable information. And a relevant work that we did was a brief for the U.S. Supreme Court in a case called IMS Health versus Sorrell. And at issue in that case was the disclosure of the doctor prescriber records to a data mining firm. The state of Vermont had passed a privacy law to try to protect that information. The data mining firm claimed that it was simply discriminating against them, that the doctors could disclose this to many other parties. And interestingly, the U.S. Supreme Court essentially accepted that, said a real privacy law would have been more restrictive. Now, we wrote in that case an unusual brief. We said that the court wasn't aware of it, but in fact there was a privacy interest of the patients, because what they thought was de-identified was in fact not de-identified, both because by inference you could figure out who the patients were, and also because the hashing algorithm MD5 had been broken. And that hashing algorithm was developed by Ron Rivest and broken by Bruce Schneier. Both of them signed on to our brief. So it's a very important point you're raising. It's a very, it's a very interesting issue, but I think it's a little too soon perhaps for a final judgment on whether anonymization is possible. So please, some more questions. Yes?
For my PhD, I'm trying to look into and trying to move past the personal, non-personal dichotomy. I see that you both involve risk and harm in your conceptions, in your projects. I was wondering what kind of taxonomy you were using for your, as a basis for what constitutes risk, what constitutes harm. I haven't found one in the European context that has been non-controversial, so I was wondering what you were using.
We actually spoke with the French CNIL regulator about that, and they said that Granted, it was hard for companies to implement, but the 3 steps: anonymous, pseudonymized, and personal data was still the categories that they were working based on. So in their case, the anonymous category is built. It's 3 conditions that you can find. It's the opinion of the G29 Working Party, where they elaborate the 3 conditions for anonymity that are incredibly hard for companies, or for anyone for that matter, to test. But on a theoretical basis, let's say, those are the 3 categories that define for them what anonymous data is.
So in our study, we didn't look at necessarily the issue of risk per se, but the actual incidents where we perceived there to be a breach of the law and some type of resulting harm or impact to the individual. And we decided to categorize breaches on the basis of unintentional versus intentional behaviors. And for us, the conclusion, we didn't make conclusions on that basis per se, but we related it to the fact that regardless of it being unintentional behavior, breaching data protection rules, it could still lead to a very great deal of harm and impact to individuals. So for us, harm was much broader than what is provided in the current directive. It's more than emotional distress, it's more than financial damage, and our biggest finding was this idea of potential for harm, because in a lot of the cases we found, the data were never recovered. The data I mentioned that were sold on the black market are involving HIV positive patients. We have no idea of knowing what harm might come to those individuals and at what time in the future. So that case in the US will be really interesting to see actually if actual harm is required, but that's kind of the taxonomy that we worked with in our study.
Go ahead, sure. Yes.
The taxonomy is really interesting. Controversy I often see when it comes to that kind of unclear harm is how to evaluate it, how to measure it. Did you try to answer that in your study or not?
It was very much a scoping review for our funders, but I think that we do not think that compensation should be limited by the fact that you can't quantify it in the terms that were such as financial damage, because we found that to be a great failing of UK law currently, that they provide for emotional distress under the Data Protection Act, but you can't actually recover anything unless you causally connect it to financial damage. So the awards in data protection cases are really minor, I think £80 or something like that, and it's ridiculous. So it's I think, and we do not think from our report, we didn't conclude that you should always have to quantify harms.
Right. So if I just add quickly on this last point, I mean, there is a paradox about data theft as compared with physical theft, because if your money is stolen or your laptop is stolen, you see the object is gone, you can assess the damage, and it's very concrete to you. Where, of course, if data is taken, it's on the one hand as if it didn't happen, and on the other hand, the impact could almost be unbounded, because you actually don't know what the potential consequence could be. Could have 100 impacts on your financial life that you would not be able to measure from the act. So it's very interesting. Yes, please, another question.
Thank you for some interesting presentations. I would like to learn from your work if you learned any kind of solution to the bad governance problem.
Yes.
Someone works on that.
That's your next paper, maybe.
Yeah.
More work.
We just need some awareness campaigns, and then we're all fine. Or is it the DPOs? I mean, please.
So my day job really is looking at how we can develop good governance practices in the context of administrative data, which is a very wordy way of saying basically any and all public sector data. And in the health sector in the UK, my colleague, Professor Laurie, worked on something in Scotland where they developed a good governance framework. You can look it up online, and it's for the Scottish Health Informatics Program. And their governance framework is really based on this idea of proportionality and also risk-based assessment. And the idea, at least when you're talking about health data in the public sector, they felt the principle of the public interest should really be a guiding factor when you're talking about proportionate uses of data. So it is not just in the public interest to protect individual privacy and data protection and informational interests in that data. It's also in the public interest to put to use data for health research, for healthcare improvement and services. So that is really a guiding principle, which has then been adopted by the Scottish Government in their approach to data linkages. So that's something to definitely look at. I haven't found a solution myself, but I have a year to figure it out.
Maybe picking up on that, because I fully agree. We've been working with private companies to try and see whether that model would be useful for them to kind of think of their broad, how they organize data flows inside of their organization. And we found that they actually think it's quite useful for them to use that, a variant of that model to say, okay, we're going to design our data flows internally, and we're going to say this is personal information, this is private information that we can use for commercial purposes, and this is the information that is sensitive and that we're not. And tagging that information from the start for them has proven quite useful in understanding from which of those categories you can move to from one to the other, but not in the other side. I think they found that quite useful, and we've gotten positive feedback on that point.
Thank you. Another question. Actually, I have a question, and maybe while others are thinking about the presentations. My question is, what role do you think transparency plays in providing assurance to the user or data subject that the technique for de-identification works, that the assurances of data protection work, or good governance mechanisms are in place? How do you see the relationship between transparency and your work?
Well, I think it's more or less the most important thing that we have to think about, because many of the mechanisms that we develop are rather hard to understand for the end users, and so it's even more important to have good explanations in systems or products, so that the people can understand what actually happens in the systems without knowing in detail how our mechanisms work.
I fully agree. I think part of what we try to do is precisely to provide categories for transparency. So this is what we're doing with your data. So this is data that we're not going to be touching because this is yours, and we don't have the right to process it. But this, on the other side, on the silo-centric model, this is data that we're going to be sharing with other companies because that's how we are going to make our money. And so providing transparency on those categories. So, for example, on the silo-centric model, we say, okay, well, there's like maybe 3 or 4 policy options. The first one being, okay, we disclose the silo that we're participating in. So we say we are exchanging data with this and this and this company. The second measure is, well, not only are we actually exchanging data, but when we offer you a contract, we're saying this has been personalized based on data that we found here and here and here and here in the silo. So I think that building transparency in the model is
and if I can follow up, I mean, this is transparency, not simply a notice that says we use your information for reasons that benefit you. I mean, this is actual transparency. This is some ability to see the data collection technique and who has access to the data and the use of the data in that sense. Okay.
So in the UK, I don't know if any of you were familiar with the care.data debacle. No? So data from GPs or general practitioners in England were going to be transferred to a sort of data center and then reused for various purposes. And that was particularly interesting because there was legal authority to do that, but there was such public backlash. And that, again, for us is really signposting to the importance of public acceptability, but transparency and real meaningful engagement with the publics that you're impacting. If you're going to claim that something is in the public interest, you need to identify the publics that you're actually talking about and engage with them and see what they think about what you're doing. So in the case of care.data, the fact that it was lawful did not mean that they had the requisite social license to actually go about their enterprise. So as far as I know, that initiative has actually stopped because they're backtracking now and trying to do proper public engagement. So I think for good governance, the model that we're developing, public engagement is key. And I think that relates to transparency, and it goes beyond notification. It's much more meaningful and dynamic than that for it to be meaningful to the data subject.
Wow. Okay. Fascinating. Yes, please. a
I
computer.
find it really interesting. I think I'm from Denmark, and then the health researchers they are so convinced that they actually do research for the greater good, which is true. I mean, the benefits of the society, everything that's in the whole idea of when you can collect data for the greater good. So they are very far away from this whole public debate awareness, at least in Denmark. I don't know if it's a similar situation because they're so convinced themselves that what they're doing is making sense for the greater good, so they don't need this dialogue.
We've been working with researchers to try to develop an easier language for them or dialogue to communicate the value and the public interest in their research, because a lot of the times there is inherent public value in what they're doing, but they're not communicating it to the public. So that awareness needs to be raised in order for them to really legitimately rely on the fact that what they're doing is justifiable because it's in the public interest. That needs to be communicated to the public, and it needs to be an exchange of ideas.
I would say I have worked with, I do privacy stuff, and I've worked with people who are medical researchers, and one of the things when you have in context that's actually really ironic is the people who program the data to have the most social impact are actually under the most rules, whereas stuff like Fitbit is virtually unregulated, so like the Walmart example, et cetera, there's really no prohibitions on that. But if you are a medical researcher, the number of both non-legal kind of internal hoops you have to go through with like institutional review boards, and then like you have a rule called HIPAA and stuff like that. So actually I think people, at least in the US, the people who are trying to do the most are actually also the most constrained to the point where they're kind of shaking against it. And like, well, how come these advertising firms do all this stuff for no
That's a fair point.
Yeah.
If I could just quickly follow up on that, in our research, there wasn't a single incident related back to medical research in academia. All of the incidents were from public sector organizations outside of university and academia, and that's something that is not communicated. Research use is often safer, but
Anyone else? I'm happy to call you. I just wanted to see, did you have a question?
Yeah,
or-
very specific
Sure,
questions.
go ahead.
Well, about your research. So at some point there's this emergency two-way communication. Did you also think about the nurse side of communication? Because if they're visible on the displays in the corridors, they can be assessed on their efficiency in handling emergencies, for example.
So this data is also not stored in our system. It's just the live stream that's submitted to the mobile phones. And we were thinking that's more important to sort of balance the observation between the patient and the nurse than to protect the nurses in those seldom cases when they have to handle the emergencies. So I also assume that once the nurse is on site and has to take care about the patient, then she will just switch off the device because she has other things to do.
Fascinating. Yes, sir.
In your classification of sensitivity of data, what are your thoughts about genomics data, pedigrees, and all those things?
My personal thoughts are different from, but I think within the model, it depends. So, for example, 23andMe, which is the first example that comes to mind when you talk about genomics, is a company that is using that data to inform all of their users about the correlations between genomics and potential sicknesses. In that case, it would be stylocentric because it's the company that is collecting the data to then provide a service to the user. It's not the user. If I was taking my genomics and processing myself, or if I was the first recipient of that information, then it would be different. But in that, I think in that model, it would fall in the second category of data. I don't know if that answers your question. My personal views is that
And
genomic.
if you want to protect really DNA information, to do it today, is there a possibility to really anonymize genomic sequence? How to really protect those things?
I don't have a good answer for that. I think I am not sure that you can imagine to have anonymous genomic information. I'm not sure how that would work. With the three criteria fixed by the D29 Working Party, I'm not even sure that you can actually apply those to genomic data. So I have trouble understanding exactly how it would work with genomic data.
Very good. I think this is a good place to stop. There'll be another panel in this room in just a couple of minutes on privacy and surveillance. But again, I wanted to thank all of our panelists for their excellent presentations.